Good morning. We'll be getting started in just a few moments. Today, we're talking about changes in Connecticut's employment law, and our Councils and Conversations is presented by Avelo Airlines, now bringing service to New Haven to Florida starting in November. We'll get started in just a couple moments. And again, if you're just joining us, we'll give it another minute and then we'll get underway. Thanks everyone for joining us this morning. This is our Councils and Conversations, C Squared, presented by Avelo. Fly from New Haven nonstop to Florida at aveloair.com. And today we're talking about changes in Connecticut employment law. First, I want to take a moment to thank our sponsors who help us put on this programming and so many of our other programs. Today's program is brought to you in part because of all of the investors that we have here at the Chamber that support us throughout the year and allow us to do multiple different webinars as we go throughout the course of the year. Today, we have our program brought to you by our HR Council, the Human Resources Council, which is presented by Carmody, Torrance, Sandeck, and Hennessy. And we would like to introduce to you our excellent panel that we have this morning. I'm going to go through each one of them, and then we'll turn it over to the team from Carmody to be able to start the presentation and start to get your comments in. So first we have Sarah Healy. She's a partner at Carmody. We're also joined by Nick Zano, a partner at Carmody. Tom Curtin, he is the corporate director of HR at Ulbrich Stainless Steels and Special Metals. And Jennifer Falzone, VP of Human Resources at Marrakesh. So at this point now, I'm going to hand it over to Nick and Sarah to start us off and start talking through some of the many changes that we've seen in HR law. And then what we'll do is we'll start to take your comments, questions into the chat. We'll work those in and we'll hear from Tom and Jennifer as well as what they're seeing at their firms. So Sarah, Nick, go ahead.
Good morning, everyone. Thank you, Garrett, for that introduction. As Garrett said, my name is Sarah Healy. I'm joined here with my colleague, Nick Zano from Carmody. We are both attorneys in our labor and employment practice group, and we are excited to be here with you and thank the Chamber for inviting us to review new laws and recent updates impacting employers in Connecticut. As many of you probably are very aware, we have had some very significant developments in Connecticut this past year. Therefore, we do have a very packed agenda to review with you. Our intent is to provide an overview of some of the important highlights of the laws that have been passed, along with some other updates that have come out of the federal government as well. And we're very lucky to have with us here today Tom Curtin and Jennifer Falzone, who will be providing their insights from a business perspective as HR professionals, so that they can add to this by adding some of their insights on what they're seeing in their workplaces and how they intend to implement some of these new laws and adapt to them as they come out. And with that, as you can see, this past year has been really a blockbuster year for new legislation. These have included the legalization of marijuana, and Nick is going to talk a little bit about how that impacts employers and what employers need to think about as we begin to see those laws come into play in the next year. We're going to talk a little bit about the Crown Act, age discrimination and employment applications. There's been some expansion of rights for breastfeeding mothers in the workplace. Another really big one and important one that we're going to discuss is some big developments with respect to wage equity and disclosure of salary ranges. We're going to talk about that today as well. And then there's a host, as you can see, of other legislative updates, along with, of course, we can't go through an employment law update without talking about some updates related to COVID-19 and the vaccine. So with that, I'm going to turn it over to Nick now, who's going to address recreational marijuana.
Great, thank you, Sarah, and good morning, everyone. Thank you for joining us. The Connecticut law that was passed legalizing recreational marijuana is known as the Responsible and Equitable Regulation of Adult Use Cannabis Act, otherwise known as RERACA. So that's what I'll refer to it as I go through this presentation. When Connecticut passed RERACA, it became the 19th state in the United States to legalize recreational use of marijuana by adults. There are a whole host of components to RERACA. Legal possession of marijuana became legalized as of July 1, 2021. Adults aged 21 and older are permitted to possess 1.5 ounces of cannabis on their person and up to 5 ounces in their car in the trunk or a glove box. Retail sales will begin in Connecticut by the end of 2022, and the sale, manufacture, delivery of marijuana would require a license. So somebody can't just go and begin selling it without obtaining a license. And at least half of the licenses to sell marijuana will be given to, quote, social equity applicants. And those are individuals who've been most negatively impacted by laws prohibiting illegal drugs. Qualifying patients, these are individuals who use marijuana for medicinal purposes, will be permitted to cultivate up to 3 mature cannabis plants within their homes beginning October 1st of this year, October 1, 2021. And then all adults aged 21 and older will be permitted to grow a similar number of plants indoor in their homes beginning July 1, 2023. The law also, importantly, especially for employers, erases certain prior convictions, marijuana-related convictions that occurred between January 1st, 2000 and October 1, 2015 are automatically erased. And then there is a process if an individual wants to seek erasure of other convictions regarding marijuana that an individual can go through to get those convictions erased. And so, as you can see, this law really will become implemented, fully implemented in phases. There are a number of employment-related protections under the law that we will discuss. Those are not effective until July 1, 2022. So there's really nothing immediate that employers need to do right now other than become informed and start thinking about what they want their policy to be. Like there is a significant amount of discretion that the law affords employers. With that said, there is one aspect of the law that is effective October 1st, and that involves, on the next slide, that involves smoking in the workplace. So effective October 1, 2021, all employers must prohibit smoking and the use of electronic nicotine, that's e-cigarettes, e-cigars, electronic nicotine and cannabis delivery systems and vapor products in any area of any business facility under the employer's control. And so the business facility refers to the actual structure, the building where employees work. And so this requires employers to adopt a policy now prohibiting the use of any sort of vaping products, nicotine delivery system, smoking, anywhere in the building. And then the law states that an employer could certainly designate not just the building, but the entire land and real property also as non-smoking. And so if you don't have a policy on that, you should develop one in the next week or so before October 1st. So what I want to do now is just kind of go over some of the key takeaways from the RERACA law. So on the next slide, the first thing for you to be aware of is that some employers are altogether exempted from all the employment-related provisions under the law. And so what that means is exempted employers, and the list is on the screen, exempted employers can basically continue to discipline, if they choose to, employees or refuse to hire candidates who test positive for marijuana, even without a policy in place. Like there's nothing they need to do if you are exempted to take any action. You can continue to operate under the current policy that you have. RERACA doesn't change that. The only caveat, obviously, is you cannot discipline a qualifying patient, somebody who uses marijuana for medicinal purposes, because there's an existing law on the palliative use of marijuana. But if you are an exempted employer, you can continue to operate as you wish with respect to marijuana. How do you know if you fall into one of these categories? Well, the statute refers to the North American Industry Classification System, the NAICS, and you might recall that that's the same classification system that our sick leave law uses. And so Manufacturing, for example, has NAICS codes 31, 32, and 33. If you go on the NAICS website, you can easily or should be able to easily determine if you fall under one of these exemptions. Another key takeaway is that some positions are also exempted. So on the next slide, there are certain positions that even if the employer is not exempted, there may be positions within the company that are exempted from the employment law protections under the Act. So firefighters, police, EMT, where it says requires a position that requires operation of a motor vehicle, it's really narrower than that. It requires operation of a motor vehicle for which federal or state law requires testing, like CDL. So it's not any operation of a motor vehicle. And so there are some other ones there on the screen. The other one that I did not include, but I think some of you may be impacted by, is any position that is funded in whole or in part by a federal grant. And so if you have a position that is exempted, you don't need to worry about the employment law provisions under the Act, under RERACA. Next slide. So as I said sort of at the outset, RERACA does give employers a lot of discretion to continue to prohibit marijuana. And in the workplace, all employers, exempted or not, may continue to prohibit employees from performing duties under the influence of marijuana. All employers may prohibit employees from possessing, using, or otherwise consuming marijuana while performing duties around the premises of the employer. The only caveat, again, is for individuals who are qualifying patients. Individuals who use marijuana for medicinal purposes are permitted to possess marijuana. So you can continue to have a policy that has these two pointers in the policy. The challenge, of course, which we'll talk about for a minute, is how do you prove that somebody is actually under the influence of marijuana at work? And so we'll turn to that in a second. Another key takeaway on the next slide is that regardless of whether or not an employer is exempt, so if you're not an exempt employer, all employers may implement a policy, a written policy that prohibits the possession, use, or consumption of marijuana by an employee, even outside the workplace. Again, the only caveat is with respect to qualifying patients. You cannot violate the right of qualifying patients to use marijuana outside of work, and you cannot restrict the right of a qualifying patient to possess marijuana. So even for marijuana use outside the workplace, if employer wants to prohibit that and say that if we test you and you test positive, that is a violation, you can do that as long as you have a policy in place. So you have to have a written policy in place. It must be either electronic or in a physical form. It has to clearly state the restrictions on the possession, use, and consumption of marijuana, either at work or outside of work. It must be made available to employees prior to enactment. Obviously, you need to enforce it in a uniform manner. For new hires, it needs to be provided when a conditional offer of employment is made. And so if you want to continue to take the position that you prohibit marijuana use, regardless of whether it's in the workplace or outside the workplace, you can do that as long as you have a policy in place and as long as it protects qualifying patients. If you do not adopt a policy and you're not an exempted employer, so you're covered under the employment-related provisions, then you are restricted. Then you cannot take adverse action against an employee or a prospective employee because they either use or don't use marijuana or smoke or vape or use other cannabis products outside the workplace. And you cannot take adverse action against a prospective employee as well. So without a policy, you are subject to those restrictions. With a policy, you have complete latitude to prohibit marijuana use. You can continue to require employees to be subject to drug testing under Connecticut law. So if you have reasonable suspicion, you can continue to have applicants undergo drug testing. The question, I think, for employers is whether you want to continue to drug test for marijuana. It just depends on what position you ultimately want to take on that. The law actually gives you the discretion, if you reasonably believe that an employee is under the influence of marijuana at work, to take action even absent a drug test. And so the law says that employers may take appropriate adverse or other action if they determine that an employee manifests specific articulable symptoms of drug impairment while at work in the workplace. And it goes through various factors for you to identify what that is. And so in some respects, it actually gives you a little bit more rights to take action against an employee who appears to be under the influence of marijuana without actually undergoing a test. And so kind of what should employers be doing now, given that you have a year to think about this, or a little less than a year? One, become informed. On the next slide, determine what position you want to take. Do you want to treat marijuana like alcohol use? That whatever employees do outside the workplace, you're not going to take adverse action. But if anything happens in the workplace, obviously, just like alcohol use, you will take action. Or do you want to prohibit marijuana use under all circumstances? Do you want to take the position that, whether you use it in the workplace or outside the workplace, we want, as an employer, a policy that prohibits marijuana use? And then obviously you need to take a look at your policy and revise it to reflect the position that you want to take. So the law does afford you that discretion. So with that, I'll pause here. If anyone has either any questions, feel free to put those in the chat feature, or if the panel wants to comment at all on Tom or Jennifer, if you have any thoughts on recreational use of marijuana, or positions that you might be considering at your respective organizations, feel free to jump in at this point.
Okay, I'll go. So we fall under one of the exempt categories. We're a human service agency, so we do fall under it. However, we have decided that we're going to remove marijuana from our drug panel. We do require new hires to have a drug test upon offer. But that's the only time we actually drug test staff, unless we suspect impairment at work, and then we send them for a fit for duty test. So we're going to maintain our impairment policy that we currently have, because it does talk about legal and illegal drugs and being impaired at work, and what the consequences of that. We have a checklist for management. So if they do suspect that somebody is impaired, there's certain behaviors that they have to observe on this checklist before we send somebody for a fit for duty test. And the only concern we had was what you mentioned, that there's not a test that will show, I took marijuana or smoked or whatever 2 hours ago or 2 days ago. So that was a concern if someone is impaired at work, how we would handle that with a fit for duty test, because it doesn't actually prove that they were, smoked marijuana or ingested it in some way right before work or at work. So, that was our only concern, but we're currently working on removing it from our drug panel now, and we're not going to be testing for it going forward.
Thank you, Jennifer. This is Tom Curtin, and we're going to be doing the same thing here at Albrook. We are going to be stepping up our reasonable suspicion training for supervisors to make sure they can identify signs of impairment. And, that's pretty much it for right now. We'll contemplate other options as we learn more about the legal landscape and take it from there.
Makes sense.
And I'm seeing here, we do have a question from Sherry. Let's see. Clean Air Indoor Act. Nick and Sarah, are you seeing the question in here?
Yeah, I do. I am not aware of that particular requirement from DPH, so I really can't, or the Department of Health, so I really can't comment on that. I think the question has to do with posting, that it's a smoke-free facility, I imagine. But I don't know. I can't comment on that question. We'll try to get back to you on that, Sherry.
Great.
Okay, I think that looks like it's it for questions at the moment. We can move on to our next topic, which is the Crown Act. This was actually already enacted. It was enacted in March of 2021. So it's already, and it went into effect immediately. So this is already an effective law, but we did want to review it since it is somewhat new, just to make sure that everyone is aware of it. The Crown Act changes the definition of the word race as it is used in Connecticut's anti-discrimination statutes under our current laws to specifically include ethnic traits historically associated with race, including but not limited to hair texture and protective hairstyles. And under the law, it also specifically sets out that protective hairstyles include wigs, head wraps, and hairstyles such as individual braids, cornrows, locks, twists, bantu knots, afros, and afro puffs. And that's actually described out explicitly within the statute. So what are some key takeaways for employers, and what do you need to be thinking about with respect to this new law? Essentially, any employer who has a dress or appearance policy should review that policy to make sure that it doesn't prohibit any of the hairstyles that are now covered by the law, either explicitly or by implication. We should consider avoiding kind of using subjective hair or grooming requirements, such as hairstyles should be professional, as these terms can be difficult to apply and may mean different things to different people. Again, while policies requiring hair to be kept neat or clean are likely still permissible, we should just ensure that our policies, as we do with all of our policies, are applied equally across all employees and hairstyles. So that's essentially the requirements under this new law. And then turning next, we have age discrimination in applications. The purpose of this is somewhat obvious, I think. Its purpose is to prevent employers from screening out older applicants as they review resumes that are coming in and applications that are coming in for new hires. Employers are prohibited from requesting or requiring a prospective employee from disclosing on their initial employment for application any of the information identified here on this slide. So age, date of birth, dates of attendance at an educational institution, and dates of graduation from an educational institution. There are some exemptions, and those include requests for that information when it is for a bona fide occupational qualification or need. The one that comes to mind, for example, would be in order to be a bartender, you need to be 18 years of age. So something where you actually do need to meet a specific age requirement to hold the job. And then when such information is required to comply with another state or federal law. This goes into effect on October 1st, 2021. So employers should make sure that you review your current job application forms to ensure that you are not asking for this information. You might also want to review your job positions to see if there's any position that does have to have a certain age requirement. And make sure that people who are involved in the hiring process and are interviewing candidates are aware of this new law and the fact that we should not be inquiring about individuals' age or these dates of graduation at educational institutions. So then turning to another topic, we also had passed this legislative session some additional protections for breastfeeding employees. And you all, I'm sure, are aware that currently under our current law, employers are required to make reasonable efforts to provide a room for employees to breastfeed in private, and it can't be a toilet stall. That has been, it's been a bit expanded now. So unless you can show an undue hardship, the area that you're providing for employees for breastfeeding purposes must be free from intrusion and shielded from the public. There should be an access to a refrigerator or an employee allowed to have their own private kind of refrigeration device, like a cooler or something. Access to an electrical outlet also needs to be provided unless you can show that it's an undue burden to provide these things. And that again that's a high threshold. So you'd really have to be able to explain very specifically why you're unable to provide and meet the requirements of this law. And this goes into effect on October 1st of this year. Moving to our next topic. This one has to do with the salary range disclosure. And this was a big change under our Connecticut law. And so we're going to spend a little bit of time talking about this and the requirements under it. It too goes into effect on October 1st. So we need to really start thinking about making sure that we're ready to comply with this law when it goes into effect. This was passed as a series of steps in Connecticut. that the state has been taking over the past couple of years, focusing on eliminating wage discrimination based on gender. I'm sure, again, most of you are aware that recently employers were prohibited from asking prospective employees about their wage and salary history. That was another step that's been taken in this effort. Employers can't tell employees that they are prohibited from disclosing their wages to one another. So this new law kind of builds on that process. And it sets forth how and when employers must disclose the range of wages for their positions. It expands this, and it also expands the standard for gender-based wage discrimination, making it easier for employees to prove gender discrimination in wages. And we're going to talk about that a little bit later. This can be kind of a tedious process to comply with this law, looking at all your positions and coming up with the appropriate wage ranges. So it may take some time and effort right now, but I think actually it's a good thing for employers to do, and it will have some benefits in the future once you get this set. And it will help, I think some employers who I've talked to who are engaging this process, has helped them really look comprehensively at their positions and what are the appropriate wages, and forcing them to analyze to make sure that they're up to date with market trends and having fair wages across the board. So moving on to some of the specifics. What do you have to do under this law? Essentially, there's two buckets that employers must be able to provide at two different times, two categories of wages available. So when an applicant is applying for a position, you must provide the wage range for that position either at the applicant's request or prior to or at the time of an offer of compensation is made. For employees, you have to provide the wage range for their position when they're hired, when there's a change in their job position, or again, at that employee's first request for that wage range. So as of October 1st, you could conceivably have employees begin to ask you, what is the wage range for their position? And you will have to be able to provide that to them, as that is as one of the new requirements under the law. So moving on to the next slide. So how do you determine a wage range? So this is obviously one of the big questions as you're looking at complying with this law. What do you need to think about? The law provides some examples of how you can think about this. So the range of wages an employer anticipates relying on when setting wages for a position, that's what it says. And this can include any applicable pay scale, previously determined range of wages for the position, the actual range of wages for employees holding comparable positions, or the budgeted amount for the position. And basically, you need to have a reasonable explanation for what your range of wages is. And I think we've had questions in the past where some employers have said, well, maybe I'll just have a wage range of say $60,000 to $200,000. That's my wage range for that position, just to cover the gamut. That's not reasonable, and that would not be acceptable under this law. But as you can see, it still does give you a fair amount of discretion to analyze for yourself how you're going to look at these positions. And I think it helps to understand on the next slide how the law has been expanded with respect to how we look at discrimination in wages. And I think this is something you need to understand before you do look at your wage ranges as well. So we're going to go over the standard and then I'll kind of tie it all together for you. So under Connecticut law currently, employers cannot discriminate against genders in wages. So basically it says right now, you get equal pay for equal work. Two employees performing the same duties should have equal pay. What we're going to be, the new standard that is going into effect October 1 is equal pay for comparable work. And so that makes the standard a little bit lower for an employee to show, well, I don't have to show now that I'm performing exactly the same position as my colleague to show that we have a difference in wages. I only need to show comparable work. And that's defined as two or more employees exercising comparable level of skill, effort, and responsibility under similar working conditions. So I think it helps when you're looking at your wage range for positions, as you need to analyze to a certain extent who are in comparable positions and make sure that your wage ranges reflect that and are fairly set across those comparable positions. You can have wage differences between genders, but they must be traceable to something not related to gender, such as seniority, merit, productivity, differential systems based upon your education, your training, your skills, your experience, or geographic location. So some employers who have multiple facilities in different states, you can permissibly have a different wage range for someone in Connecticut than, say, Florida or Texas. But again, it has to be set reasonably. So I think it's important to look at this a little holistically and make sure that when you are analyzing your wage ranges, that you're looking at comparable positions. Because if an employee is going to bring a lawsuit, which they have the right to do under this law, saying that they're not being paid appropriately in comparison to someone of the opposite gender, that's going to be the standard that the court's going to look at. They're going to look at comparable positions and see, you know, if there is indeed a difference.
So Sarah, before we move on that topic, just some thoughts. I mean, I'd be happy to hear from Tom and Jennifer too about how you guys are tackling the wage ranges and just your strategy on that. But I was at a conversation recently with an employer, and we discussed the wage ranges and just some things that we had kicked around. One, not a bad idea to develop a policy. You know, when you announce that you're going to have salary ranges or you begin implementing salary ranges, it's probably not a bad idea to have a policy or some sort of explanation that goes with it and that provides the caveats for maybe how you came up with the wage ranges, that they're subject to reevaluation periodically based on market and business demands and just changing conditions and situations. You might explain in your policy, you know, when employees are their right to see, you know, to request the wage ranges, just so that you're being completely transparent and that you're also explaining that while you have these wage ranges, they are subject to change. And I think you can have a wage range that is narrower than what your actual pay is. Like, you may have an outlier. You may have an employee who is paid beyond what you would think would be an acceptable wage range for a particular position. And then there are a whole host of different strategies for how you determine the wage range. And you know, you could take the average salaries or the average hourly rates in a particular job classification, you average them, you come up with the mean, and you decide that you want to go 20% over and 20% below the mean and say that that's the wage range for that position, and that's okay, as long as that is a reasonable range that you would use if you had to hire somebody for that job. The one thing that, and it'll be interesting how this plays out sort of in the market, is, you know, applicants in particular, but employees too. Like, it really makes companies and employers' wages more transparent in the marketplace, right? And so you may find that if you adopt a wage range that has a low high or a low low, and an employer, an applicant says, the wage range at this company for this job is blank to blank, you know, this other company has a wage range that is this to this. Like, it actually becomes a little bit of a feature or a tool that can be used by, you know, in the marketplace to determine where employees want to work. And so these are just some considerations that I would throw out there for you to give some thought to as you take steps to implement this policy. But Tom, Jennifer, do you guys have anything that you want to add to the discussion on this? I know it's a hot topic for employers.
I'll jump in. Tom Curtin with Albrecht. So yeah, Albrecht is constantly monitoring, you know, our wage ranges, and of course this law makes it all the more critical to do that on a consistent basis. And we have, you know, internal equity is always so important, particularly when you're considering new employees. You don't want to upset the balance of wage ranges and so on and so forth. I kind of like the idea of going with actual range of wages for employees holding comparable positions. That seems to be pretty practical because it does take into account internal equity, which is again critical. In some cases with new employees, it might be a good approach to go with a budgeted amount for the position because the range will be a little narrower than what you typically see, which is 20% on either end of the midpoint, which is a very wide range. And you certainly don't want to be getting into a situation where with a new employee, they see the top end of the range. And of course, they go right at that top end and say, I should be paid up here because of this, that, and, because of my credentials and experience. And, that gets to be a difficult conversation. So yeah, lots of things to think about here. But I think, we will be able to get through it, come up with a process that makes sense. And we're all about transparency anyway. And, this becomes easier with hourly positions because, our scales are, just a lot more, neat and clean and well-defined. It gets a little trickier when you're talking about salaried positions. I don't know if that helps, but it's not the issue.
I think that was really helpful.
So for us at Marrakesh, because we're a nonprofit, it's a little different for us because we are primarily funded by our state funding sources. And currently, one of our biggest funding sources is the Department of Developmental Services. And just recently, they passed sort of a minimum wage for our direct care staff and what they start at. So that is what we start our direct care staff at in our DDS programs. But ours is primarily based on the budgets that we get as a nonprofit. We've always been very transparent. We put the either hourly rate or the salary on most of our job postings that we put out, and primarily because we are a nonprofit and so we can't always pay a higher salary. So we just want to put it out there before anyone even waste their time interviewing with us if that's not a salary that's acceptable to them. But generally our salaries or our rates are connected to the position and not the person. That's basically how we've been doing it for a long time. So anyone that's hired as a program manager starts at such and such rate or salary. And then we generally have a like 10% increase for anybody who's promoted up to the next level. And that's how we've been doing it for quite some time. So we're always looking at our wages, and we do have some positions that have a holdback for the first 6 months. So it starts at 1, and then after 6 months, when they pass the provisional period, they go up to another salary. That's always listed in our new hire letters or position change letters that we give to employees, so they're well aware of that when they're hired. So that's generally how we do it now. So it seems like, although we're always looking at that, we're kind of already falling into this standard. So that's basically how we do it.
I have a question myself about the new law, and perhaps we can direct this toward Nick and Sarah. When we promote somebody internally, we typically give them what we call an internal offer letter. And we mention their new salary and other entitlements that go along with the position. Do you think that now we need to put their range in that internal offer letter? I'm just throwing that out there.
Yeah, I mean, I think you could. I think the way the law is set up on when you have to tell them the range, it's at the time of hiring or a change in job position. So if that sounds like what you're saying is it could be a change in job position.
Well, you could read that as a change in their current position, like added responsibilities or whatever, versus, a new position because they're getting promoted into a new role. So that's a little ambiguous, but
I don't think it hurts to put it in there, to do it that way. Nick, did you have any different
Yeah,
thoughts?
no, and Tom, you can just say, again, because you can define the wage range, if it's, as the budgeted amount for the position, you can say your new rate of pay will be blank, this is the budgeted amount that we have for this new job, as it's currently been redefined, or for this new promotion, if it's a promotion. So I think you could do it that way. But I think for new hires, it says prior to, at the time a conditional offer of employment is made, you may want to build it into your offer letter and just say, welcome to the company. Your hourly rate of pay will be blank. This is consistent with the salary range that we have for this position, which is from blank to blank. Again, the law gives you discretion on how you want to define that range. It gives you some examples, but you don't have to pick one of those examples. You just need to kind of decide for yourself in a reasonable way. If you had to go out today and fill that job, you had to go to the marketplace, what would you anticipate the range of wages would be that you would pay to hire somebody for that job? And that's your range. So I would look to build it into your offer letter for new hires, and you can do the same for promotions too.
I guess just to throw this out there, if you go with a budgeted range for the role, it's almost like a snapshot of a period in time. And the person coming in the door can say, well, is that just coming in the door, or, what's the more complete range? What's the broader range? So it begs those kinds of questions. And
yeah, I agree. I think the budgeted, that really kind of fits for a single incumbent job to me. Like it's kind of an odd, it's sort of an odd system to use for a job position where you have multiple employees working in that job classification. Like it doesn't really convey much of anything to just say, here's your hourly rate of pay. That's what we budgeted. Like, I think that seems more appropriate when you have a single incumbent type position and say, yes, the amount that we budgeted for this year is this amount. That doesn't mean you're locked in. We reevaluate that on a year-to-year basis, something like that.
Mhm. I understand.
Yeah.
Yeah, good thought.
That's a good point. One other thing that I'll add, just if you are looking at comparable positions and analyzing that, make sure that you look at your job descriptions as well, and that the duties reflected in those descriptions accurately reflect what the person is doing. I've had recently a case that is a wage discrimination lawsuit where it's gotten tricky because what the person actually does day to day is not matching up with the job description. So, that happens over time, especially as positions evolve or people are promoted into different positions and it's changed around. And if your job description doesn't accurately reflect that, that can cause confusion for employees and make it difficult to say, well, this job really isn't comparable to this other job if the job description makes it seem like it is. So just keep that in mind as you're looking at that. It's always a good idea to periodically review your job descriptions, and this can be a good time to do it as you're making these changes. And then I'll pause. I don't know if we have any questions. If anyone has any questions they want to add to this topic or any others that I went through thus far before I move on to a different topic. Just take a moment. It looks like we did have a question about the new age discrimination in applications law. And someone's asking about they have a licensed program where the state requires all head teachers and camp directors to be at least 21 years of age. How we handle this requirement? Well, under the law, you can ask for age based on another Connecticut law or federal law, and it sounds like this would meet it. So I think you can say that someone needs to be at least 21 years of age to hold this position, and you can ask for verification of that. Really, if you think about it too, this new law is meant to prevent employers from screening out older applicants. That's really the purpose of it. This is just setting the minimum age that meets a state requirement. So I think you're fine with that. If you have any further questions about that, please feel free to reach out to me. But that's something that you can do under this new law. Okay. All right, I don't see anything else. I'm gonna move on to our next topic. Let's see. This is a very narrow law that was passed this past year. It applies only to specific industries identified on this slide. And it essentially extends recall rights to laid off employees of these covered employers. So it applies to hotels, lodging houses, food service contractors, and building service enterprises with 15 or more employees. And it states basically that if someone was laid off from one of these places due to the pandemic, that employer now has to give that person the opportunity to come back when a new position is opened up. They have to have that first opportunity for the position. If there's multiple employees who have been laid off and a position opens up, you go to the employee with the most seniority first to offer them that position. And it applies to individuals who are employed for at least 6 out of 12 of the months preceding March 10th, 2020, who then were subsequently laid off. So again, this is a very narrow but important law if you are an employer who falls within this industry. Okay. And then, as you all know, in October of 2019, we had a very robust sexual harassment training requirements that went into effect. And the CHRO recently has said that employees who complete their mandatory 2-hour sexual harassment training by participating in the training through the CHRO. So as many of you know, the CHRO has put its own training out on their website that employees can utilize to meet the requirement under the law. They're able to transfer their training hours to new employers if that training was completed within 2 years of the transfer. But it's only for employees who did the training via the CHRO training. So employees who participate in a third-party sexual harassment training are not eligible to transfer their prior training when they've gone to a new employer. They must be retrained. And I think that answers some questions that employers have asked us in the past about how frequently you have to do it, especially if an employee came from another employer just recently and just was trained. It's only transferable if they were trained through the CHRO. And then I'm going to now turn it over to Nick to address some other developments.
Yep. So Sarah, one other question came in on the salary ranges, and the question was essentially, can you provide the salary ranges verbally instead of in writing? My understanding is the statute does not say that it needs to be in writing. And so I think you can provide it verbally to an applicant or an employee, but think about whether you want to take that approach, because if somebody brings a claim saying you didn't comply with the law, the law allows for a private cause of action against the employer for failing to comply. So I think you can do it verbally, but you might have an issue proving that you did it if the employee claims they never got it. And then you just need to keep careful, records of that, and then careful records of what you told people verbally, and make sure that you're being consistent. So I think technically the answer is yes. The statute doesn't say it needs to be in writing, but I'm not sure that would be the best approach from just protecting yourself standpoint. I would probably advise, employers to do it in writing, just so that one, you can show that you did it, and two, you are consistent. You didn't, an employee didn't hear one thing and another employee heard something else on the ranges. So.
Yeah, I completely agree with that. From a litigation perspective, I just think of a case where we get a complaint and filed, and the employer's telling me, but I told them it was X, Y, that was the range, and we have no proof. And it's then a he said, she said. I think it just opens you up to a lot of misunderstandings as well, especially if you can't confirm that you've been consistent in how you've told others the range. So I would agree with Nick. I would not recommend doing it verbally.
So I'm going to go through now a couple of laws that sort of, I think, flew under the radar a little bit because they were passed in connection with the budget implementer. There's really not much context behind some of these laws, although you'll see some of them are fairly significant. So starting in the third quarter of 2024, any employer that has 100 or more employees has to include in their quarterly DOL filing certain information about each employee, and it's quite extensive. You have to give for each employee information about their gender identity, their age, their race, their ethnicity, their veteran status, their disability status, the highest education completed, their home address, the address of their primary work site, the occupational code that Bureau of Labor Statistics has for each position, their hours worked, their days worked, their salary or hourly rate, their employment start date in the current job, and then their current, if applicable, their end date. And so that is for each employee. So if you have 100 or more employees, that starts the third quarter of 2024. If you have 99 or less employees, you've got to start providing that information by the third quarter of 2026. So again, this is way out. I'm sure there's going to be more information in the coming years. And then if you have less than 49 employees and you don't have an electronic payroll system, you don't have to provide it until the third quarter of 2028. Again, kind of way out there in our world, but it's not really clear how this information will be used. So we just it was passed this past session, so we wanted you to be aware of this. I'm sure there'll be more to come as these dates get closer. Another kind of peculiar law, and I can't really understand the context for this one either. On the next slide, Sarah, has to do with education or tuition reimbursement programs that employers with 100 or more employees must notify their Connecticut resident employees if they offer an education assistance program. And if you do offer a program, you've got to provide the details of that program, the benefits that are provided, the conditions of that program, which in my experience, most employers do anyway. Like you generally want to tout if you have an educational reimbursement program or a tuition reimbursement program. But in any event, now it's a legal requirement to do that in writing. And the law sunsets on December 1st, 2024, meaning it goes away. Then it no longer is applicable anymore. So again, kind of a strange new law that was passed. On the next slide, the law concerning workers' compensation protections for employees who assert their rights under Connecticut's Workers' Compensation Act was broadened. So previously, the law prohibited employers from discharging an employee who exercised their rights in the Workers' Comp Act. That's all it did, is prohibit a discharge. Now it's been expanded to say you cannot discharge or discipline or discriminate against an employee who files a claim for benefits or exercises their rights under the Connecticut Workers' Compensation Act. It also says that you cannot deliberately misinform employees regarding workers' comp, and you cannot deliberately dissuade an employee from filing a workers' compensation claim. And so perhaps the context for this was COVID or is COVID, in that, there are questions coming up. Maybe employees are saying, I got COVID, I'm not sure if I got it at work. And the employer says, well, I don't think you could have, and sort of dissuades that employee from filing a workers' comp claim. Or there's an injury, the employee says, I'm not sure, my shoulder's really bothering me. It might have been from what I did at work. And the employer says, well, maybe not, maybe it was something else, and sort of dissuades the employee from filing a claim. Again, now the law specifically says that you cannot misinform or dissuade an employee from filing a claim. And so our general advice has been to let the employee file the claim and then let the insurance company do their job, which is to analyze that claim. The next slide. Effective now, again, this sunsets too. So this law goes away June 30, 2024. Employers have to provide 2 unpaid hours for an employee to vote as long as the employee requests that time off at least 2 working days in advance. And what elections apply? All state elections, special elections for U.S. Senator, U.S. Representative, state representative as well. There's no provisions for municipal elections, so it's just 2 unpaid hours from work. This probably requires that you adopt a policy about time off for voting, and it needs to comply, with at least these requirements. You could certainly provide time off for other types of elections as well. And so the last thing I wanted to just touch on, and then if we have a few minutes, we'll leave it open for some questions at the end, is I'm sure all of you heard about President Biden's plan for the path out of the pandemic. This was announced on September 9th, 2021. There are 6 parts to his plan. One is vaccinating the unvaccinated. That's the one that is of particular interest to employers and the one that we'll talk about. But he also has, as part of his plan, further protecting the vaccinated, which involves booster shots, keeping schools safely open which involves getting all students eligible for vaccinations, increasing testing, increasing masking, protecting economic recovery, and improving care for those with COVID-19. But the first one, vaccinating the unvaccinated, this is the one that got a lot of attention. President Biden announced that OSHA will develop a temporary emergency standard that will require all employers with 100 or more employees to mandate vaccines or require weekly testing. And so on the next slide, federal law basically allows OSHA to issue an emergency temporary standard without any notice or rulemaking. Typically, when an agency drafts regulations or proposes a rule, it has to go through an extensive comment period. It has to allow the general public an opportunity to look at a draft rule and provide comment. And then the agency considers those comments and then perhaps makes revisions to the rule to address some of the comments that have been raised. And so this is an unusual step where OSHA would be issuing an emergency temporary standard. It's done it before without any notice, without any rulemaking. They can do that when there is a need to protect employees from a, quote, grave danger from exposure to a harmful substance. And so once that emergency temporary standard is adopted, it stays in effect for 6 months, and then it needs to be replaced, if at all, by a permanent standard. And so no rule yet has been issued by OSHA, but we expect one in the next couple of weeks. Once the rule is promulgated by OSHA, in every state that does not have its own OSHA, the rule is automatically effective immediately, right? But in Connecticut, we have our own OSHA agency, and so the rule does not automatically take effect in Connecticut. So as soon as you hear in the news, and you're going to hear it, OSHA issues a new temporary standard, it will not be automatically effective in Connecticut until OSHA develops measures that are just as effective as the federal rule. And so that's going to happen. OSHA needs to do that within 30 days. And then once they do that, then the rule applies to every employer with 100 or more employees. Every private employer would then need to be, would be covered under that rule. And you know, there have been many questions that have been raised about this new rule, and there just haven't been answered yet because we don't have the actual OSHA rule yet. But some of the questions on the next slide are, how do you count the 100 employees? You know, does it apply to employees who are working at home or in a remote area where they really don't have interaction with a lot of workers? You know, do employers collect proof of vaccination? Who pays for the weekly testing? What type of testing? Is it a rapid test, a PCR test? You know, does it apply to a worker who already had COVID? You know, when you count employees, is it per location, part-time, joint employers? Do you count employers under common control? And so there are a whole host of questions that have come up, and, you know, we do expect, and I've already seen legal challenges to this. The Arizona, on the next slide, on September 14th, rather, just about a week ago, the Arizona Attorney General filed a lawsuit challenging the administration's new mandate, calling it an unconstitutional exercise of unbridled power. And questions are certainly going to come up. You know, can OSHA really mandate that employees pay for the testing? You know, is that within the jurisdiction of OSHA, or does that need to be carried out by the Department of Labor? Does the Department of Labor need to go through rulemaking? So there are just a lot of open questions on this. You know, what I would say for you as employers is to continue to keep an eye on this and think about, if you have to implement this emergency temporary standard, how you're going to do that. You know, do you have 100 employees, and then how would you carry that out? So I see that there are a bunch of questions in the chat. I haven't even looked at them yet, but we have a few minutes. Why don't we go through some of these questions and any other questions that folks might have, or Tom and Jennifer, if you want to add anything on the, you know, President Biden's order, now's the time we can do it. Otherwise, let's go through some of these questions.
Yeah, it seems like we've got some, you know, Nick, question about, is it 100 actual employees or 100 FTEs? Do we have an answer on that yet?
We really don't. My guess is it's going to be, it's just a guess. It's just going to be part-time and full-time employees. It's just a straight 100. Do you have 100 employees or not? But again, until we see the actual rule that OSHA publishes, we won't know. By the way, once OSHA publishes the rule, I mean, it seems a little unfair if you're sitting there saying, well, they're going to publish it on Monday and then we have to comply by Tuesday or by Monday afternoon, right? Typically, they'll wait 75 days, you know, to enforce that rule. And so there is a little bit of time to kind of figure it out, read it, understand it, and then apply it. But not a lot of time.
And I know this is the big question. I'm pretty certain there's not an answer on this yet either, but if will employers be required to pay for the testing?
Yeah, I mean, that's a great question. You know, it's not known at this time. I think, you know, when he announced the rule, he did say that employers would need to provide time off for the employees to get the vaccine. But he did not address, President Biden did not address, you know, if an employee opts for the testing, who pays for that? And it's a similar question that has popped up in Connecticut for state employees. And for those of you who are subject to Governor Lamont's Executive Order 13G, you know, that requires employees to be tested, to get vaccinated or be tested on a weekly basis, there have been some questions, well, who pays for that? And I think it sounds like the prevailing view is that the employees would be required to pay for it, because it's a mandate that the state is putting on the individual employees, not that the employer is doing unilaterally, right? So I think an argument can be made by analogy that President Biden is doing the same thing here. He's making it a federal law that every worker needs to comply with. It's not a unilateral policy mandate that an employer published on its own, right? I think in that case, I would say the employer needs to pay for it because it's an employer policy. Whereas where the federal law now provides it, or state law now provides it, it's no different than a licensing requirement. In order to do this job, this is what you need to do. And so that's on, I would say that's on the employee. But again, until we see the actual rule from OSHA, we can't say that with certainty.
One other question I saw, if someone resigns due to the vaccine, employee vaccine rule, will that person still qualify for unemployment?
Another great question. In fact, I was just on another webinar a few days ago where that same question came up, and it was specifically asked of the, I think it was the DOL commissioner, and she basically said, look, we evaluate these on a case-by-case basis. So sort of ducked it a little bit, as she must, because you really do evaluate unemployment claims on a case-by-case basis. But, you know, perhaps, again, on a quit, it's got to be good cause attributable to the employer. And so I think in that situation, if an employer resigns, you know, I don't know if resigning because they don't want to get vaccinated is going to allow them to collect unemployment. I would probably say no. You know, if they resign because they have a medical condition and therefore cannot be vaccinated, you know, that would be, I mean, that might be a more compelling unemployment claim, you know, if the employer for some reason cannot accommodate that medical condition. Maybe in that circumstance they would collect, but I don't know.
Running tight on time. Let me get, there's one more question here in the chat about the posting law for smoking and about where you need to post, and also the sign height requirements.
Yeah, the law is definitely effective October 1. So that is in a week. And so I'm just not, I mean, the law that I had looked at under the RERACA did not talk about the posting requirements. And so if anybody else has anybody even in the group has any information about the posting or the 4 inches high letters, please jump in. I'd welcome your views on that. Otherwise, we'll have to follow up. We'll follow up with Garrett in the chamber and provide some information on that specific question.
Great. Well, Nick and Sarah, great stuff. Tom, Jennifer, anything you want to add as we close out here?
No, just thank you for having us.
Yeah, thanks for having us. Great to be here, and good luck to all.
Yeah, it sounds like we all need it. A lot of things that everyone has to adjust to coming out of these laws that are now going into effect. So again, big thanks to Carmody, the HR Council, Nick and Sarah, Tom and Jennifer. Thank you so much for joining us, and thanks to all of you for being on with us today. Have a great day, everyone. And I'll just let everyone know, October 14th, we have our annual meeting and awards, and the Quinnipiac Business Showcase is coming up on September 30th. Have a great day.
Thanks, everyone.
Thank you. Bye.